Have you started? Because I can't hear you.
Right. Hello, everybody. My name is Ivor Blumenthal. Thank you for joining us. And we are talking to SAPMA members specifically about the amended rules and forms of the Commission for Conciliation, Mediation and Arbitration, and generally the rules which are applicable to the National Bargaining Council for the Chemical Industry, which is the bargaining council that has a purview over SAPMA members and other bargaining councils, by the way. I do need to mention in that regard that the bargaining councils will all have additional supplementary rules and have customized all of the CCMA forms, obviously, for the bargaining councils, but the principles are exactly the same. And the one thing you do need to remember is that every bargaining council is simply an agent of the CCMA. So where they carry out dispute resolution activities, which is in the name of the CCMA, conciliation, mediation, and arbitration. So mediation and arbitration are the two processes in dispute resolution. Those same processes apply to every bargaining council in the country, and there are not different rules about how to conciliate and, in fact, how to arbitrate. By the way, the notion of conciliation and mediation are the same. So in the title, Commission for Conciliation, Mediation, and Arbitration, conciliation and mediation means bringing the parties together where you don't make a decision for them as a commissioner. And arbitration means where a commissioner, in fact, has to sit as judge and jury after hearing all the evidence and considering all the factors. So the CCMA announced its new rules on Friday, the 21st of April, and they were promulgated and enforced from the 24th of April, 2023. And in fact, every second year, there is a review of these rules. I counted the other day, and I think there's been 13 reviews of the CCMA rules, although I think that this review is by far the most comprehensive. And I will mention a little later, but I also think that this review gives far more discretion to commissioners at the CCMA than, in fact, they've had in the past. It gives them far more ability to exercise their discretion, and these rules are far less directive than, in fact, they've ever been before. And I think that that's critically important, particularly in relation to the CCMA being the upper guardian of the interests both of the employee as well as the employer. I must say, as an aside, going into this discussion, I have very seldom come across a one-sided commissioner or biased policies and procedure applications at the CCMA. I need to say equally that I've found more of that bias in bargaining councils than, in fact, I have at the CCMA. It's a very fair process once you're into the process at the CCMA. Some people say that employees have too much access to the CCMA and can drag parties to the CCMA on a frivolous basis. We see a far greater application, I think, in these rules for the consequence of that, in terms of the awarding of costs in the case of arbitration, not in the case of conciliation or mediation awards, but certainly in the case of arbitration awards, we see far more focus on cost orders and how those cost orders can be applied for and how they can be granted. And that is a control against frivolous litigation, if you want, because you need to see the CCMA by the time you get to arbitration. You need to see it as a court and acting as a court in all but name. Okay, so on the screen in front of you are the various rules which are mentioned in these amendments, only two of which are substitutions, and that's 1A and 31C. Otherwise, all of the others are simply amended or simply supplemented to be cleaner and to be clearer, and also to give a lot more discretion, as I mentioned, to the commissioners in resolving or trying to resolve in phase one, which is mediation, and in phase two, which is arbitration. In fact, there is a greater emphasis on a pre-arbitration meeting between the parties to try as an intermediate space to try and resolve matters which have not been mediated, but before they get to arbitration, and we'll get to that as well. I'm not going to obviously deal with everything. I'm simply going to give you a taste or a sensitivity to what these amendments say, and we are going to send you the full amendment as well as all of the forms, all of the updated forms that you would need to make any application or reply to any application at the CCMA. So in terms of signatories, what these amendments do is these amendments say that all applications and all documentation have to be signed. However, where a document has not been signed or was signed by a person not entitled to sign or not representative of one of the two parties, there is space for the commissioner to confirm that the documents were intended to be signed and in fact or were signed even if by the wrong person, but on behalf of the party either making the application or in fact resisting the application. So there is discretion there to the commissioner to say, I'm not going to throw this matter out just because documents haven't been signed. There is a principle in law that says audit ultram partem, hear both sides of the story, and the commissioner is given more discretion here to hear both sides of the story. Serving of documents is critically important, and while I'm not going to talk about clause 5, I'm going to refer you to 1C under clause 5, because 1C is in fact the way that the CCMA would prefer for all documentation and all notices of service and confirmations of receipt of service to be handled in the future, and that's either on their online system or via email. You now don't necessarily, you don't need to go to a police station or a commissioner of oaths for an affidavit. You simply need to be emailing documentation. It's a lot simpler to prove that you've notified the other party or that you're submitting an affidavit or in fact that you're receiving a document by email or on the CCMA's online system. Eventually, the CCMA would like everything to be done on their online system, and they are regularly unlocking components of their system for users. Similarly, with the filing of documents with the Commission, a party must file documents with the Commission by either post or by hand, but mostly by email or using the online documentation system of the CCMA. And the formats are prescribed either MS Word or PDF. As a matter of security, you should never be sending an MS Word document. You should always be converting that document either into a JPEG or a PDF file when sending it on. And the one thing I do want to say to you, and that's clause number 3, a party must only file an original of a document if requested to do so by the Commissioner. A party must comply with the request to file the original document within 7 days of a request. Otherwise, copies of documents is what you should always be sending backwards and forwards, never your original documentation. Now, there is a process at the CCMA which says that if you do not do things within prescribed time limits, for example, an application to the CCMA for an unfair labor practice within 30 days of the matter occurring, if you do not do that, if you do it in 60 days or even later, you can always apply to the CCMA for something called condonation. And the application for condonation must set out the grounds in terms of why it's so late, in terms of the reason for the lateness, what you regard as prospects of succeeding with the referral and obtaining the relief sought against the other party. You need to indicate any prejudice to the other party that your lateness might be bringing and any other relevant factors. And the Commissioner will then basically apply their discretion in allowing condonation or not. Then clause 10 talks about how to refer a dispute to the Commission for Conciliation. And there is a form for that, and that form is attached in the form pack that in fact we will be distributing. That's 7.11. and you can also submit that form electronically. In fact, the CCMA would prefer you to do an online electronic submission of the application for conciliation, as opposed to any other way, including filling out the forms and posting them or handing them in. They would far prefer you to fill the form out online on the CCMA site and apply online in that regard. And that also includes the submission of all relevant documentation. Clause 3 is important. 10.3 is important. Despite any previous rules, where referral has been referred out of time, and if condonation has not been attached to the referral, the Commission will decide whether the condonation will be determined at a hearing or by written submissions received by the parties, or in fact at the commencement of the conciliation itself. Sometimes it's left as late as the conciliation itself. When must the Commission notify parties of a conciliation or facilitation, as they put it? At least 7 days prior to a scheduled date in urgent matters, or at least 14 days prior to a scheduled date in all other matters. Urgent matters, for example, are Section 189 dismissals because of retrenchment or operational reasons, or in fact strike action or something like that. The Commission may give the parties a shorter period of notice if the parties have agreed or reasonable circumstances require a shorter period. Again, there's more discretion now to the commissioners, and an additional 7 days must be provided if a notice of conciliation is sent by registered mail only. Then we see a lot of these creeping in. So clause 12. The Commission or a Commissioner may attempt to resolve disputes before conciliation. So you may get a call from the Commissioner or an email prior to the commencement of the conciliation to try and resolve the dispute before, in fact, it goes to conciliation. This has not happened, certainly not in my experience with any of my clients to date, but it is now a discretion which is being given to commissioners. Look at the matter, phone the parties, try and see what the real dispute is, because you may be able to take that matter off of the roll if you can resolve it telephonically or by email without the parties having to come in. And so that discretion is now, in fact, given to the Commissioner. I must say, it is a discretion which tends to be exercised only with group or company or mass retrenchments, or particularly in the public sector where you see state-owned enterprises going through employee turmoil. For example, what's just happened at Eskom and the resolution of the wage dispute at Eskom, where in fact the commissioners contacted the parties way before the scheduled date to try and resolve something. Didn't happen, but at least the process began before it should have happened. If someone doesn't pitch for a conciliation, now remember, the conciliation is trying to get the parties together. It's marriage counseling, if you want. So if someone doesn't pitch for marriage counseling, then the Commissioner can determine we're going to proceed or we're going to adjourn for 30 days, giving the other party time to pitch, or in fact, we're going to conclude the proceeding by issuing a certificate that the dispute remains unresolved. And the one thing I do want to implore upon you is, if you pitch for a conciliation or mediation and the other party doesn't, and that's the person who actually has been dragging you to the CCMA, make sure that in that certificate that the dispute remains unresolved, that all the necessary factors are in fact mentioned by the Commissioner on that certificate, that the respondent was there, that the referring party wasn't there, that the Commissioner tried to contact the referring party, but the referring party was uncontactable, etc., etc., etc. Because remember, the behavior of the applicant in particular, but also sometimes the respondent, in the mediation process can be taken into account. Not the content of submissions, but the behavior, particularly non-attendance, can be taken into account during arbitration. Sometimes what happens is that an employer will apply for conciliation, know they're not going to get anywhere, not even come to conciliation, and then automatically apply for arbitration. Now, if you're able as the responding party to show the Commissioner of the arbitration, the arbitrating Commissioner, that in fact you made yourself available, you wanted a pre-arbitration engagement for mediation, and the other party just didn't pitch. That's an aggravating circumstance, particularly if you want an order of costs for the arbitration. It's an aggravating circumstance by the time the arbitration is concluded. So try and make sure that everything you need is recorded on that certificate of non-resolution. If the commissioner is asked to exercise their discretion, then they need to take into account whether the parties previously failed to attend conciliations, any reason given for non-attendance, whether conciliation can take place in the absence of one or more of the parties. In other words, whether you can go ahead and come to an outcome in the conciliation without the other party, which is highly unlikely. If there are multiple parties, then it's more likely. The likely prejudice to the other party of the commissioner's ruling. In other words, the likely prejudice to you, the guy who's attended, and to the other party, if there is any other kind of ruling, and obviously any other kind of factors. There is something that is critically important at this stage that you need to bear in mind. Your company may fall under the National Bargaining Council for the chemical industry. And if it does, and it's a voluntary party because it's a member of the Surface Coating Employer Association, then in fact the CCMA doesn't have jurisdiction over your company. So if one employee or a group of employees have applied to the CCMA for a matter to be heard against you, let's say it's a matter which is unfair labor practice, you can say, hold on a moment, in terms of clause 14, the CCMA doesn't have jurisdiction over this matter. The National Bargaining Council for the chemical industry has jurisdiction over this matter. And therefore, the Commission doesn't have jurisdiction to conciliate the dispute through conciliation. And the matter must be cross-referred back to the National Bargaining Council for the chemical industry. And all you need to do, if you're going to aver that, and we say in limine, which means before the conciliation's actually begun, where you're turning around to the Commissioner and saying, Mr. Commissioner, you don't have jurisdiction here. If that's the case, then all you have to do is prove that you're a member of the Surface Coating Employer Association or a party to the National Bargaining Council for the chemical industry. And that has to automatically then be taken off of the roll at the CCMA and referred back to the National Bargaining Council by the chemical industry by the party that made the application, invariably the employee. The employee will be sent to the NBCCI to make the application again, and not the CCMA. The CCMA, if it doesn't have jurisdiction, should not proceed with a matter. However, we have had instances in the past where the CCMA, despite being told this is not in your province and you don't have jurisdiction, the CCMA has tried to conciliate. And you can elect, we're all here, we might as well just go through conciliation. You can elect then to take the result of conciliation through to the National Bargaining Council, because if there's an application for arbitration, then that matter should be referred back to the National Bargaining Council and not heard by the CCMA. The Commissioner has the discretion to extend the period of the mediation process, the conciliation process, and it would be the directorate at the CCMA that make the decision. And they've got 2 days within which to make a decision as to whether or not the conciliation period can be extended or should be extended. A certificate issued that says that disputes have not been resolved must identify the nature of the dispute, the parties, in the referral documents as identified by the Commissioner during the conciliation proceedings. And in terms of Rule 15, anything else you want as the respondent who did bother to pitch up on that certificate, showing that the applicant has been acting in bad faith. So it's at that stage that you ask the Commissioner to indicate that on the certificate. The one thing that you need to know is a conciliation or mediation process is in camera. It is sealed. Anything that's said cannot be used in arbitration down the line, and the Commissioner cannot be called as a witness in arbitration in terms of what he's heard. So you can go completely moggy, you can swear, you can raise all kinds of allegations. And because the mediation process is a safe space to try and explore all opportunities. None of that can be used against you at a later stage. Okay. Section 17 is quite important. And depending who you are, whether you're the respondent or the applicant, sometimes may be utilized as a trap. So if one of the two parties, either the respondent or the applicant, says, we don't think there's any hope in conciliation here, but we want the commissioner to see the attitude and the behavior of the other party during conciliation, then that party will ask for con arb to in fact be what is granted by the CCMA. And all this means is that the CCMA will in one session move from trying to mediate and conciliate a matter to arbitrate a matter. The benefit for the person who believes they're right is that they will move through to arbitration and a neutral decision being made quicker than the parties who are really there to try and resolve and reach an amicable settlement during mediation instead of getting to arbitration. It is either party's right to immediately apply for an exemption to con arb taking place. My recommendation always is don't consent to con arb. If you get a notification from the CCMA that there is a con arb on a particular date at a particular time, which means conciliation and arbitration are going to run together one after the other, you can object to con arb, and any party objecting to con arb immediately splits the two sessions apart from one another. So it doesn't have to be, so if you're going to object to conciliation, arbitration taking place at the same time, this process says you've got to notify the other party of your objection and then notify the CCMA, which means you simply send an email to the other party and then you send an email to the CCMA and say, we object to con arb taking place. And they have to automatically allow con arb to be split. It's not something that can be forced upon you if you do not want to participate in a joint conciliation and arbitration process. And Rule 17 will explain how to do that and what the import of it is. So if you've been through mediation and mediation has not been successful, and now you're the applicant, normally the employee, and by the way, I just want to at this stage say both the employee and the employer can make an application to the CCMA. So if you are the employer, you can equally apply to either the CCMA or the bargaining council to resolve a dispute. If you consider that what the employee or the employees are doing to the company is as unfair as if it had been an unfair labor practice from the employer, you can equally make an application. So if mediation, if there's a certificate to say conciliation hasn't worked, mediation hasn't worked, then either party can apply for arbitration to take place. And there is a process and there's a form to apply for arbitration online as well as in printed form, 7.13. But I would recommend you rather use the Official Commission's electronic referral online portal. It is much better in terms of just keeping information in one place, having access to that information, et cetera, et cetera. And there's a process applying for arbitration, and there's a process for filing statements, and statements of case, statements of response, material facts, any evidence which still needs to be gained, or something called discovery. All of these applications would be made to the CCMA to force on the other party by way of your filing a statement or an application to the CCMA. This page here, I'm not going through all the points on this page, but I mentioned this page to you. It's clause 20 of these amended rules, because this is the most critical part of arbitration if you are going to go to arbitration. It is a pre-arbitration meeting. It is a process of pre-arbitration. And really, it is very much the meat in the middle of the sandwich, because the CCMA is trying to force the parties after mediation to come together again and to talk about all the nuts and bolts of arbitration in such a way, and invariably about 60% of arbitration never happens because the pre-arbitration conference normally results in what is referred to as ad idem, a meeting of the minds, where parties have had time to digest the facts, digest the consequences of an arbitration award, explore an opportunity for some kind of a middle ground and a meeting of the minds. And 60% of the time, the pre-arbitration process works as a second stage mediation, but without the commissioners present. By the way, you can request that the commissioner is present during the pre-arbitration process, but invariably the commissioner will say, no, you guys have to meet, but we do want minutes of the process. We want to hear that you've done from 3A all the way through to R. You've discussed, are there any means for resolving the dispute? Do we agree on the facts? Which are the actual facts in dispute? What is it that we're asking the commissioner to decide when we go to arbitration? What relief do we want? What documents are we going to share or do we want from the other party? That's called discovery. How do we want the documents? Do we want affidavits, or are we prepared to, just accept statements from the other parties? Who's going to begin? Do we need to have an on-the-spot inspection? Are we going to question witnesses and have the commissioner available during the questioning of the witnesses, etc., etc., etc.? And as you go through all of these points in pre-arbitration, you tend to find a common space. Invariably, like I say, 60% even more of the time, you tend to not need to go to arbitration because you're going through a more sophisticated way of mediation between the parties. And also because at this stage, invariably, it's professional lawyers or professional representatives who are in the meetings, as opposed to a highly emotionally charged employee who's the applicant, and maybe an HR person who's the respondent representing the company way out of their depth. Rule 25 is most probably the most important rule that you need to get your minds around. And that is that when you get to, well, to start off with, in the mediation process, who's allowed to be in the room and who's not? So, for example, an employer is entitled to have any employee, any manager, or any consultant that's an HR consultant to the company responding during the mediation process to the case which has been lodged by the employee. But the employee is not entitled to have a lawyer present or any external person present unless they belong to a trade union. So at best, if they don't belong to a trade union, then the employee is only entitled to have another employee present representing their interest. But if they don't belong to a trade union, invariably they will be forced to represent their own case. Now, 9 times out of 10, they might have an advisor, and the advisor might be sitting outside the room, and they are entitled to go outside the room whenever they want to, just by asking the commissioner for a break to consult with their advisor. It might be an HR practitioner or a legal advisor or somebody who's a friend, and they're entitled to. Now, invariably, they're entitled also to ask the commissioner to allow that person into the room to represent them. Under the old rules, the commissioner really didn't have discretion, but the commissioner now has far more discretion to allow a party during mediation, during the conciliation process, to in fact be represented. And they normally look at clause C2, where they say, what's the nature of the questions of law which are raised in the dispute? Is it likely that an employee would understand these questions? How complex is the dispute? Is it in the public interest that the employee be allowed to be represented? And is there an imbalance of power between what the company can afford, or who the company can afford to send to these sessions, and who the employee has to rely on to represent them or represent their interests? So there's a lot more discretion which is given to the commissioner in terms of the application of Rule 25. But I do implore you to read it, because it gets very tricky when it comes to representation during arbitration. There's a lot more flexibility during conciliation than there is during arbitration. During arbitration, it would have to be a trade unionist or an employer, a lawyer representing the trade union, representing the employee who's bringing the action, or it would have to be a representative of the company, or an employer association, or a lawyer who's being commissioned by the company to represent their interests. So it's far more of a court case by the time you get to arbitration, and that's why you have to get your heads around Rule 25 in terms of representation. It's my feeling, or my experience is that it's far easier for a company to be represented than it is for an employee to be properly represented during mediation and during arbitration. If the person is not a member of a trade union, then the commissioner will invariably allow them to bring a lawyer in to represent their interests because they don't want an imbalance of power. Okay, so what happens if a party fails to come to arbitration? And if the party is the employer, and invariably it is the employee who's applying for arbitration, the commission, and specifically if the party was a referring party, the commissioner will then, in the absence, on the face of it, a willful or unexplained absence, or the explanation from the applicant or the respondent is not accepted, the commissioner can remove the matter from the roll, or can continue with the proceeding in the absence of the other party, or adjourn the proceeding for a later date. But the one thing the commissioner will push for is proof that the other party or the absent party was aware of the date, the time, and the venue of the proceeding before making any decision. And that's why they are moving more and more over to an electronic system of control, because those notifications are automatic. So Part 6 is really the meat and potato of these amended rules, because it's how to make an application, whether you're applying for condonation, or you're applying to join parties or substitute parties, or a variation in the original application, or a variation in order of an order, or rescission of an order, or for a postponement, or for disclosure of documents, or if there's a jurisdictional dispute, or any other interlocutory application. Don't worry about that word, but any application to the CCMA. There are forms and there are processes which in fact are prescribed in these amendments and also in the forms that you need to take notice of for any of those applications. Clause 10, however, of the applications is important for you to know. Despite the rule, the commissioner or a commissioner may determine an application in any manner it deems fit, provided that the commission or the commissioner informs the parties of how the process will be conducted and gives the parties an opportunity to be heard. Audit altrum partem. Hear both sides of the story. So this gives commissioners a huge expanse of discretion, irrespective of factually what has occurred in terms of the rules of Part 6. And if you understand this Clause 10, you will understand that you, because the commissioner has far more discretion, you as either an applicant or a respondent have far more ability to play on that discretion of the commissioner than you've ever had in the past, of being reasonable, of showing cause for the commissioner to exercise their discretion. It just gives you far more of an opportunity than ever you've had in the past at the CCMA or in the bargaining councils. Picketing rules only apply to people embarking on industrial action. In other words, collective action where they've gone on a strike or a go slow or something like that. But there is a process where the parties who want to picket would first have to apply to the commission, to the CCMA, for authorization to picket, where the rules of picketing would need to be agreed between the parties. In my opinion, this Clause 31A is very often a way of delaying or postponing industrial action so that the parties can try and be mediated or mediate themselves through the process, instead of, having a strike outside, intimidating customers and clients, or in fact intimidating staff not to come to work. Where the CCMA has given an order, a compliance order, or in fact one of the parties in writing has signed that they agree to do certain things, and these things do not happen, or one of the parties doesn't comply with the order of arbitration, then 31B is a rule of how to bring an action at the CCMA forcing compliance, asking for an order of compliance. Because if you've got an order of compliance, and it's normally an order of compliance which is a financial consequence, that order of compliance can be taken to the sheriff of the court's office, who are very, very accessible. And there's a very small fee to ask the sheriff to execute an order of the CCMA as if it was an order of court. And it might result in assets being confiscated, or even in the civil arrest of someone, or the criminal arrest of someone because of non-compliance. And it is the sheriff of the court, and by extension, the sheriff of the CCMA, who would be considered to be the enforcement officer of any order in terms of 31B of the CCMA. If a matter is thrown out because of time or non-condonation, or parties haven't come to the meetings, and the matter has been struck off the roll, you can always apply to have it re-enrolled, and there's a process to consider, well, there's a process to apply for re-enrollment, and then there's a process for the re-enrollment to be considered. And ordinarily, especially if it's right at the beginning of the dispute resolution process, in other words, mediation rather than arbitration, the CCMA is very open to matters being re-enrolled. Certainly on my previous applications, and I've done a number now, I've never had the CCMA turn around and say no. Sorry, in one instance, I did have the CCMA turn around and said no, because they questioned the affidavit of someone, in fact, who was dead and couldn't speak for themselves. But outside of that, no, I've never had a no for re-enrollment. There is a process of being able to apply for the rescission of an arbitration award or ruling. And you have 14 days from the date of the award being issued, or from the date on which the applicant becomes aware of the award. You have 14 days to apply for rescission of that arbitration award. The rescission will not take place in matters where Rule 30 is affected. In other words, one of the parties is not pitched up to either bring the matter or defend against the matter. But outside of that, there is a process for rescission, and that's Rule 32. If a matter is not dealt with within the CCMA effectively, or to your interpretation effectively, you can always ask the CCMA to refer a matter onto the Labour Court, and there are rules for referring to the Labour Court. But once the matter is referred to the Labour Court, it can't come back to the CCMA unless it's referred back to the CCMA. And the Labour Court is a proper court of law, only lawyers, only judges, and only witnesses. I like to say that in dispute resolution, in labor relations, any matter which goes to the Labour Court is a failure for both sides. Because if a judge has to decide on something which has to do with the emotional relationship between an employer and employee, both parties have failed. And particularly the company has failed in terms of the application of fair process. Not all the time, but some of the time. You should be trying to resolve the matters within the bounds of dispute resolution rather than the Labour Court. Section 188, which is part 7, 188A, is the same as Section 189, and you should all be familiar with Section 189, which is the idea that you're going through a process of looking at either for operational or financial reasons. You are looking at the potential consequence of retrenchment, although there are other alternatives to retrenchment, but the potential consequence of retrenchment. Section 188 is that clause that deals with mass retrenchments. Normally over 50 or more employees within a 90-day period. whereas Section 189 deals with less than 50 retrenchments or less than 50 people who are affected by the consequence of a Section 189 process. And if you look at the process of 188, it's the same as 189. The notice has to be given to employees. There has to be a consultation period. Normally, it's a 30-day period. The CCMA needs to be asked to facilitate if there's no agreement on mass retrenchments. The facilitation process has to take place, and the resolution has to be either that there is resolution or the matter should be referred through to the Labour Court for some kind of a resolutive decision. There are forms to seek condonation over a variety of issues that we've already spoken about, and that process is dealt with by Clause 35. There is a good explanation of what expert witnesses are, how many days' notice they need to be given to attend, whether they should...
Are you still talking?
Sorry? Sorry, I can't hear you.
No, sorry, I couldn't hear you for a minute. I think it was my connection there. You can carry on, sorry.
Okay. There is a provision for payment of witness fees, although there is also a provision for the commissioner to say, hold on a moment, there won't be witness fees paid by the party who requested the commission to issue the subpoena for the expert witness or any other kind of witness. And if the commission itself has asked for an expert witness, then the commission must in fact pay the witness fee or seek a way of waiving the witness fee. So there are fees for witnesses. Now, Section 39 is the sexiest, I think, of all of the provisions in this entire bundle of provisions. So there's nothing to stop an employee from going to the CCMA on frivolous charges of unfair labor practice against the employer. There's nothing to stop them. The CCMA has an open door policy, and anyone can lodge an action at the CCMA. The process of mediation is on the CCMA. The CCMA covers the costs of mediation. But the consequence of wasting your time as the employer means that if this matter does go to arbitration, and again, it's a frivolous application. Everybody can see it's a frivolous application. The employee is just trying to push their luck because they're not happy with the settlement offer you gave them during mediation, or they're not happy that they didn't get a settlement offer and they want a settlement offer even if they don't deserve it. And they're counting on the fact that you don't have the time and attention span to see the whole thing through and you'd rather just settle. And so they apply for arbitration because conciliation has been unsuccessful. And you go through arbitration. And in fact, as the company, the CCMA finds in your favor, then you are entitled, under Rule 39, to apply for an award of costs. And I'm not going to go through the process of how to apply and how the commissioner exercises their mind, but I just want to point you to point number 4. Point number 4 says that an award for costs in terms of sub-rule 3 is in the amount of, for the first day of arbitration, 7,000 Rand for your representative. And from the second day onwards, 4,700 Rand for your representative. And if it's a candidate attorney, in other words, your representative is not a full-blown attorney, but a candidate attorney, 50% of those fees. Now, what this does is 2 things that you need to be aware of. It sets the expectation in the mind of the applicant that if I beat you, I'm going to take your house, quite frankly, because you've wasted my time. I'm going to get an order for these costs, and if you can't pay the costs, I'm going to get the sheriff to repossess every single asset you own. That's the first point. So you can take as long as you want during arbitration, because every day is at least going to cost you 4,500 Rand. But the first day is going to cost you 7,000 Rand. And if we're in arbitration, be sure I'm not going to rush the activity. So that's the first thing that this order of costs does for you as the company. The second thing it does for you is this. It pegs the fees of the attorney that you're hiring that you're commissioning to represent your interest. Now, you might have seen Dali and Porfu, who's charging 50,000 Rand a day. And there are many attorneys out there who want to charge you 15, 20,000 Rand a day, especially because they know that arbitration is invariably going to be 1 or 2 days and not a week or 2 weeks. But what you've now got is under Rule 39 of the CCMA, you're entitled to say to any attorney, you can't charge me more than 7,000 Rand for the first day and 4,500 Rand for every day thereafter. And if you're going to put a candidate attorney on the job as well and charge me for that person, you can't charge me more than 50% of these rates. Because it's there under clause 4 and 5 of Rule 39 that you can point them to. They can, of course, turn around and say, well, then we're not going to represent your interest. But there'll be many attorneys who will be prepared to work for those rates. But at least you now have those rates pegged, and you know what it is it's going to cost you to defend yourself in an arbitration hearing. Whereas previously it was really open up to what your guy wanted to charge. Okay. Part 8, which is the general part of these regulations, make Rule 40, certification and enforcement of any arbitration awards. There are forms for that process. And if you need to bring an enforcement action against the other party, the Rule 17, 718 and 718A would be those enforcement forms. Clause 40A, the last clause, for me is the most unfair clause because it's absolutely one-sided. It is a clause which has been designed for the employer, and normally the employer is a respondent in an arbitration. But it says, where the commissioner, having found that the dismissal was procedurally fair, orders payment of an arbitration fee, blah, 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 the arbitration fee will be paid by the employer. I have no problem with that whatsoever. But there is no reciprocal provision that over and above paying for the fees of the other side, an applicant for an arbitration order, if it's considered to be a frivolous arbitration order, that the applicant shouldn't also have to pay an arbitration fee to the CCMA. Because this is where the CCMA says, our time is costing money as the CCMA. You're wasting our time. So they've said here in Rule 48 to the employer, so we're going to punish you if you defend against a claim of unfair labor practice and we find for the applicant. But they don't say, we're going to punish the applicant if we find for you, the employer. And that's blatantly unfair. But unfortunately, it's the way these rules have been set out. And unfortunately, I need to say this, that collectively as employers, you have very, very weak representation at NEDLAC, the National Economic Development Labor Council, where all of these rules are debated and these rules are rewritten and revised. You've got very weak, very pro-government, very pro-labor business representatives who wouldn't know how to protect the interests of business if it hit them in the face. The majority of them are ex-trade unionists to begin with. So as you can see, here is a specific example of an absolutely biased inclusion in the rules of the CCMA against employers with no reciprocal obligation on employees who bring frivolous actions. That's my interpretation of Rule 40. Okay. Any questions? Anybody like to ask anything or engage on any of the issues which have been presented? Nothing? All right. So guys, thank you very much for attending, and I hope this has been useful. And like I say, a copy of this presentation, as well as the amended rules and the forms to use with CCMA applications, will be sent out to SAPMA members. But let me say, instead of you filling out these forms manually, you should be filling out these forms and submitting them on the electronic portal of the CCMAs. That would always be my recommendation, because if you've got receipt of these forms, the CCMA can never say, well, we didn't receive your application for condonation, or we didn't receive your application to split ConArb, it's all for rescission or for anything like that. But in the absence of any follow-up questions, I just want to thank you for participating. And Tara, unless you've got anything to add, or do you have anything to add?
I just want to confirm again, X568870. Can you just confirm your name and email address for me? I just want to make sure that you're on the mailing list to receive all the information.
Tara, my name is Angel. I get communication through Samantha. You send everything to Samantha Meyer.
Okay.
From the, yeah.
Okay, that's perfect. So she'll just forward it on to you then, Angel.
Yeah, not a problem.
Okay, perfect. Thank you.
Thank you.
Fantastic. Thanks very much, guys.
Thank you. Thanks, Iva.
Bye-bye.
Cheers, Donald.
Thank you, Ava.